Good morning. I have this nice book here. I'm just going to show it to you. And I like it. Why? It's 2011. In 2011 is when the Supreme Court of the United States issued its opinion on General Dynamics versus the United States. I've provided what I could so far as my commentary or reflection on that opinion. But the thing that's important about that is that opinion would have been pending connected to others that were before the court at that time, but also as a result of factors that had already occurred in connection with the 2008 election. 2011 is also when, as I've said, I was given the only legal representation I've been given in my life. Now, I did consult somebody who was a lawyer previously when me and people with whom I worked were attempting to organize a labor union, but he did not provide any official legal representation at that time. The only time I've ever had a lawyer for anything had to do with a claim submitted to Social Security Disability Insurance. It's the only time I've ever been provided with any legal counsel. And to this day, I haven't been provided with any legal counsel, and I haven't had anything close to a collegial relationship with anybody identifying themselves or attempting to identify themselves as being legal counsel, with the exception of one woman who was representing herself pro se. I would consider her a colleague. Now we are where we are, and I did not know when I composed that voice file that over the weekend was pending the publication of notices in the Federal Register specific to the Department of Defense and, among other things, considerations of the authority to engage in and provide security clearances through the Department of Defense. Now, we have had several years regarding manipulation of the so-called background check process, including up to the level of the Department of Defense. There was an executive order that was passed by former President Barack Obama concerning background checks that I contend was actually part of crime. That this concept of a background check is really about allowing for illegal underwriting to provide a sort of context to people's efforts to engage in resource acquisition or perhaps even performance of their job duties and create some form of abstracted economy with economic events or transactional moments that are reflected in the background. And that it's also a part of illegal research and development, including in connection with financial products that were allowed to be mischaracterized somehow as being about national security, when that's not the case at all. In fact, I think that in the last 10 to 15 years, a lot of alleged national security related areas have actually been a sort of cover for allowing for certain people who have participated in a particular kind of patronage to get priority, as opposed to actually allowing for people who are qualified or would otherwise be qualified, were there to be an explicit verifiable process to get what they need in order to participate. As has been said very many times, including at the level of the Supreme Court, there's a very big difference between being in execution of one's official, including ministerial duties, as opposed to being a market participant. And I contend that what has happened, especially since the onset and the implementation of the Affordable Care Act, is far too many people in the government have been acting as if they're a market participant, as opposed to somebody actually in execution of their official duties. As a matter of fact, I think as soon as Congress allowed for itself to start being an actual shareholder in the companies that were implicated by the crimes that were revealed as part of the 2008 banking crisis, that they took on more of a role as a market participant than as people in execution of their ministerial duties. And this changes considerations of not only their immunity, but also the implications of criminal activity, including the transactional immunity they would otherwise qualify for while they're actually in performance of their duties. That's kind of where we are at this moment right now. As I said, I did not know at the time that these matters were pending over the weekend, intending for publication today. But I'm bringing this up for a specific reason. Last year, what would have been about a month before now, last year, I contacted District 23 Representative William Hurd here in Texas. Why? Because in the 2009 Appropriations Act, under appropriations for the Department of Defense, were specific appropriations that I understood could have been used and implemented as an effective first response to the COVID 19 situation. As a matter of fact, the appropriations that I specifically cited were also connected to an executive office of the White House strategy regarding the Department of Defense that was published at the beginning of 2018 for implementation for 2019. It just so happened that in the autumn of 2019, concurrent to the time frame during which allegedly impeachment was being sought against the president, there was also a bill having to do with alleged emergency relief that put a preclusion on particular kinds of funding that I understood were responsible for attempting to realign or reprogram funding priorities when it came to national security, specifically national security having to do with a domestic response via appropriations concerning Department of Homeland Security and Medicare. The deadline, or rather the timeline, happened to expire or happened to go into effect at the anniversary of the date of that White House Department of Defense strategy. In that White House Department of Defense strategy were listed areas that I believed could have complemented those appropriations from the 2009 appropriations bill in order to actually provide an effective response to COVID 19. It would not have been under the authority of the Health and Human Services exclusively, and it would not have been under the authority of the Centers for Disease Control exclusively. Those items, those appropriations that had already been put into effect 10 years ago, with an understanding that some must have, that some appropriations actually take 10 years to implement fully, especially if we're talking about R&D. But these appropriations were not about research and development. These appropriations were about training, they were about readiness, and they were also about a manner in which members of the Department of Defense would have been required to coordinate with other departments in consideration of narco-terrorism, as well as chemical and biological weapons acquisition and disposal. When I say acquisition, I mean taking chemical and biological weapons away from terrorists, including domestic terrorists. Now, had there been some responsible engagement with policy, including national security policy, in the time frame from 2009 on, that understood that pharmaceutical companies and distribution networks associated with pharmaceuticals are a very ripe area for attempting to clandestinely distribute concurrently biological or chemical weapons, we would be in a very different situation than we are right now. But who would have had the integrity or the acumen around 2008 or 2009 to have been able to have engaged in a formal course of action to identify what was allegedly happening with healthcare from a perspective of understanding the potential for exploitation of healthcare policy as well as healthcare praxis to allow for distribution of illegal or illicit materials up to and including chemical or biological weapons, but also recruitment, understanding healthcare networks, healthcare providers, and especially areas where people are disproportionately impacted by environmental and other factors that impact their actual physical health, are ripe areas for exploitation by opportunists attempting to manipulate their material circumstances in order to compel or offer them the opportunity to benefit from crime. I kind of dumbfounded on one level that there wasn't more attention given to this, and instead what we've gone through for the last 10 years is an attempt to create some sort of political justification for normalization and inculcation of the street economy as a replacement for actual political praxis. While our political rights have been divested of us, we've had a concurrent process of attempting to legitimize and normalize criminal activity as some substitute for actual statecraft. This is not just about urban or racialization of the alternative organizational structures that people of color or communities that were traditionally politically disenfranchised have engaged. We're also talking about the whole casino culture supplanting actual legislative process. We're also talking about showboat kinds of scenarios as a replacement for actually being able, for instance, to exercise your rights to due process as a citizen. This concept that we're in a gaming economy so we can game the system has led us to a point where literally we're supposed to claim each other as our poker chips. And while we have a very temporary time frame with which to do so, gamble with actual people's lives. And unfortunately, more and more and more is being revealed to show that the people that should be protecting us and the people that should be standing up for us and the people that presumably are our representatives have been doing just that. I would never, ever allow myself to be represented as the kind of person that offered myself up on the auction block for somebody's temporary use and then intentionally sabotaged what I had to work with to make sure that whatever ended up happening with me being so used was as trash as possible, so it could be as discounted as possible for a quick sell-off to my opponent. But that's exactly what they started doing in 2008. And part of the reflection of that is in the fact that when 2019 came along and we actually needed things for the appropriations bill to have been able to have been revealed, which could very well have happened had there been an actual examination of other areas of the appropriations bill that had been examined during the 2008 election season, including as part of a congressional campaign that campaign to be able to get to DC, or even if that campaign, once it had lost the election, been able to engage in ordinary political process after who did win, insofar as they won legitimately, got to DC, could have been examined, could have been discussed. And in the course of that, it would have been compared and contrasted with other areas of the appropriations that would have identified how there was ongoing an outlay in regards to specific matters related to countering narco-cartelization as well as chemical and biological weapons proliferation. That didn't happen. That didn't happen. Instead, we got a misrepresentation and a misnomer of healthcare. And now we're at the situation we are today with these notices in the Federal Register. Among the things they discuss is counterintelligence. We have just had 3 years of a complete misrepresentation of whatever it is that intelligence entails through the Department of State. Now, today, we're supposed to be put in a situation, if we actually engage with our government process, where the government is allowing for representation of governmental activity to be in accordance with a recapitulation and reconsideration of counterintelligence activities involving the Department of Defense. This is after years of me personally receiving absolutely no response from any entity that's under the authority of the Department of Defense, up to and including the executives at the Department of Defense or the administration of the Department of Defense that would have been necessary in order to provide an appropriate background check to my certifications in non-destructive testing through invocation of an executive order provided by former President Bush in the build-up to the Gulf War. You may say what you want politically about your understanding of the Gulf War, but one of the major things that came as a result of the Gulf War were accusations that the United States military had been involved with the use of chemical weapons in the Gulf War. As such, it becomes very important for people in the United States to hold the government accountable, especially when it goes on the record in saying it has a policy regarding biological, chemical, and nuclear weapons, including the confiscation or the removal of them from access by national security threats or terrorists, as well as their appropriate disposal. This is not merely a matter for insurance people and brokers and people that support campaigns for people in political office to speculate on, including in connection with some sort of investment in companies that might benefit from disasters and calamities resulting from misuse and misappropriation of either the components of chemical and biological weapons or the chemical and biological weapons themselves. Instead, however, we should have been focusing on what we already had. Why did Congress engage the actions it did in November of 2019? Actions that intentionally and deliberately cut off what had already been appropriated and what could already have possibly been available for in another form of, and I believe, more appropriate response to whatever is going on with COVID-19 up until this time. I sent the information I needed to the person that was possible for me to send it to under the circumstances. In that appropriations bill, it outlines a very specific process whereby one can engage in means by which to contact members of Congress in specific roles in order to officially and legitimately engage a process around certain timelines. In March through May of last year, it was not possible through the appropriate process to contact the people that would have been needed to be contacted to engage that process. Those people were not just individuals representing a specific geographic district. So when you try to contact them through their website, well, you're not in my area code. You got to go to someone local. If you're on the Senate Armed Forces Committee, or you're on the House Committee for Armed Forces, and you try to say that because I'm not in your area code, you cannot fulfill the duties that have already been appropriated and have already been passed by Congress and have already been signed into law by the president, you're not doing your job. There was no way to actually go through the congressionally approved, presidentially authorized process of the 2009 appropriations bill in order to perform the functions that had been appropriated for 2009. So I went through the process that was available. And what happened? I contend somebody sat on it for a year, and now they're trying to flip it. See, last year, it would have been considered intelligence, wouldn't it? Now this year, they want to talk about counterintelligence. This is the problem. This was intentionally set up. Who authorized for people within the United States to aid and abet crime in the United States, up to and including organized criminal activity that aided and abetted acts of domestic and international terrorism, with an understanding that at some point down the line, it was going to flip. So all that crime they had been committed was going to swap out to somebody else, and then they were going to get credit for what? Counter intel? If there's any counter intel credit to be accorded right now, it goes back to 2008 and 2009. We have more than 10 years, 11 years, 12 years of appropriations that were intentionally sabotaged. You don't take somebody, traffic them for 10 years under some sort of alleged confidentiality connected to healthcare treatment in order to traffic them for the Department of State and representatives abusing their role in the Department of State, and then expect kickbacks from the DOD after you get another president in. That is completely unacceptable. Somebody needs to join me in an exhumation of federal appropriations that were set in motion by people who were running as candidates, among others, in the elections of the 2008 presidential and congressional election cycle that were approved, that were put into law, that were signed by the president at the time, and that would have been the budget they came in with in 2009. Instead, what did they do? That's what we need to get to right now. If there were deals that were cut during the 2008 banking bailout in order to privilege or to prioritize the interest of the financial sector at their time of need, and that was allowed to misrepresent what was actually already congressionally approved and or refuse to challenge other areas of what was congressionally approved that could be disabused, then that needs to be determined and that needs to be dealt with now. We don't have any more time and we don't have any more capacity to continue this status quo as if all of the crimes of the last 10 years didn't happen. Even if the companies of concern think that they've contractually obligated somebody to keep quiet while they just decide what they like and what they don't like, and then they erase the rest, they have no basis upon which to do that. As a matter of fact, I think every contract they've made since 2008 needs to be scrutinized. Every contract that has been allowed to be made available to broker the expropriation of personal private property in the United States and or attempt to offset what would be political liabilities based upon a refusal of members of public office to perform their job needs to be examined before it's too late. There are regulations that are pending right now saying the Department of Treasury has up to 10 years. That there's a 10-year period for certain records to be held. Please be mindful that as of 2019, I was already asking about timelines, including timelines that extended beyond 10 years. Not only that, but without actually responding to me directly, I did track down how later it was reflected in the Federal Register as well as in the documentation that was reflected, that they just determined that that was not appropriate. It wasn't relevant. 2 years ago, the Department of Treasury went on the record, the Federal Reserve went on the record with saying that timelines around documentation of underlying securities and other securities issues was not relevant. Today, they want to publish a public comment, period, specifically discussing timelines around which one can understand that documentation will be officially available and held. That is the essence of fraud. They knew 2 years ago exactly what I was asking. It was absolutely 100% relevant. They don't get to spend 2 years co-conspiring with a biological attack against their own people in concert with whatever entities globally agreed to co-conspire with them, and then just try to say 2 years later, well, we're going to give you some policy now. That's not acceptable either.